Hey, this is Adam Garner, Philadelphia ERISA attorney. I wanted to talk for a minute today about a recent case out of the U.S. District Court for the Eastern District of North Carolina. The Eastern District of North Carolina is the federal court that covers the eastern part of the state of North Carolina. And the case is interesting, not so much because of its underlying facts, but because the court in that case discussed the method by which courts decide ERISA disability cases. So, under ERISA, including for claims for disability benefits, the court applies one of two standards of review. And a standard of review is the standard that the court's going to use in reviewing the underlying decision of the administrator who denied the individual's disability benefit claim. So by default, the court is required to apply what's called a de novo standard of review, which really means that they're not applying any deference to the decision of the insurance company or claim fiduciary who decided your disability benefit claim. The court's going to decide on its own whether or not the insurance company got the decision right or wrong. The unfortunate thing is, in 1989, the U.S. Supreme Court issued a decision called Firestone Tire and Rubber v. Brutch. And in the Firestone case, the Supreme Court said if the disability plan, or any ERISA plan for that matter, confers discretionary authority on the administrator to construe the terms of the plan and determine eligibility for benefits, then the court will apply a heightened level of deference. The court will apply something called the abuse of discretion or arbitrary and capricious standard of review. And under that standard, the court is not deciding whether or not the insurance company or other fiduciary made the correct decision on a disability benefits claim or any other type of ERISA claim. Instead, what the court is deciding is whether or not that decision was the result of a reasoned and principled process. As a practical matter, what that means is the court's going to be very deferential to the administrator who made the initial claim decision, and as long as that decision is reasonable and the product of a reasonable process, it probably won't overturn it. It's really bad for individuals. And that standard of review has a really important impact on how the method through which the court resolves your claim. So most courts hold that if deferential review applies, and this is what the court in North Carolina held, then the court will decide an ERISA benefits claim on cross motions for summary judgment under Federal Rule of Civil Procedure 56. And what that means is the court is going to look at motions from both sides that say, hey, we should win and here's why, and the facts are undisputed, and the court will make a decision based on that record and that record alone. And under Rule 56, the court is not supposed to make any sort of credibility determinations or anything like that. It takes the facts as undisputed and simply applies the facts to the law and makes a decision. The advantage of a summary judgment mechanism for both parties, but in particular for plaintiffs, to the extent there's any advantage, and there aren't much, is if you lose on appeal, the U.S. Court of Appeals will not apply any deference to the trial court's decision. It's going to look at it with a fresh set of eyes, but apply the same standards that the trial court would have applied. The other method of adjudicating a ERISA disability benefits claim or any other type of ERISA claim where there's no deference is under Federal Rule of Civil Procedure 52. Rule 52 allows the court to conduct a bench trial, and for an ERISA benefits claim, you are not entitled to a jury. The cases are decided by a federal judge. And so under Rule 52, the court is required to make detailed findings of fact and conclusions of law. The advantage for an individual under Rule 52 is that the court can make credibility determinations. It can decide, for example, on your disability claim, is your doctor's opinion more credible than the opinion of the record reviewing doctor that the insurance company hired, and decide the case accordingly. The disadvantage to Rule 52 is that on appeal, the Court of Appeals will not overturn the trial court's factual findings unless they are clearly erroneous. It's a very, very high standard. But the legal conclusions are still reviewed de novo. So what that means as a practical matter is if you have a de novo review ERISA claim, you may be entitled to a Rule 52 bench trial. And if you win that Rule 52 bench trial, there's a very good chance the decision is going to be upheld on appeal. The downside is if you lose that Rule 52 bench trial, the odds of overturning the outcome of that Rule 52 trial are pretty low, unless the trial court made a very serious mistake. the reason I bring this up is this recent case out of North Carolina addressed that very issue in the Fourth Circuit. And the Fourth Circuit covers North Carolina, South Carolina, Maryland, Virginia, and West Virginia. And up until a couple of years ago, this issue was still undecided in the Fourth Circuit. But in a case a year or two ago, I guess, the Fourth Circuit held pretty clearly that de novo review claims for an ERISA disability claim are reviewed under Rule 52, and deferential review claims are reviewed under Rule 56. It's important that if you're looking to hire a long-term disability attorney who's handling an ERISA disability claim for you, that they understand these procedural mechanisms, the pros and cons of both of them, and how best to effectively employ them to your advantage in litigation. So, anyhow, that's today's lesson on federal civil procedure and ERISA benefits claims. Like, follow, and subscribe for more information. And if you need any help, shoot us a message. We'll see what we can do for you. Thanks, and have a great day.